It's been a long and difficult day already. I don't intend to make it any longer or more difficult, and I'll try to keep my remarks brief. Talking about medical bill affidavits is not exactly the most exciting thing, but it's important to both sides, in particular in a personal injury lawsuit. It's about proving up medical bills. And when the statute was enacted, it was enacted with a specific policy in mind, and that is to make sure that we can streamline and keep efficient those things that can be streamlined, and in this particular case, medical bills. The existing rule, as it exists today, allows parties to know early on in a case if medical bills are in dispute. We have to prove them up as reasonable and necessary before you can get them in at trial. And this affidavit process allows us to do that early. This gives the parties a chance to get what is undisputed out of the way with two goals in mind. One is early resolution. If we know what we're fighting about early and can have those things resolved early, it gives a greater chance of getting cases resolved early, which is important for everyone, not just the parties but the courts. Second, if you can't get the case resolved early, you can work up the case efficiently for trial. And as you move towards trial, it would make it more likely that the case will resolve without the trial. These are good goals. It's a good rule, but problems have arisen. And the problems as they have been described to me is this. Plaintiffs' lawyers at times file the medical bill affidavits with their lawsuit. As the rule stands now, the defense has 30 days to file their counter affidavit. So when a medical bill affidavit is filed with the lawsuit, the clock starts when it's served on the defendant party, such that when the defense lawyer gets the case, the clock's almost run out. Certainly they don't have the 30 days that the rule envisions that they have. I think that's a fair complaint. There may be lawyers out there that disagree with me. I think the vast majority of the Texas trial lawyers would agree that that's a fair complaint. To address that complaint, 1693 has set out a procedure where the affidavit filing, both the bill affidavit and the counter affidavit, are tied to basically the expert witness designation deadline. This, from my view, respectfully, and probably unintentionally, actually, causes more problems than it solves. If you tie the affidavit deadlines to expert witness, the plaintiff is filing their bill affidavit on their expert witness designation deadline. 30 days later, you're getting the counter affidavit saying your bills are not reasonable or necessary. Well, at that point, we don't have an expert. Also at that point, you're typically within 60 days of trial, and everybody's scrambling, trying to figure out what to do from there. And so I think that causes more issues than needed. I have proposed what I hope is a solution to the problem, and that is setting up a window in the beginning before which the defense does not have to file a counter affidavit. For example, within 45 days when the answer is due, 60 days when the answer is due. That solves the problem as stated. It allows the goals of this particular statute to be maintained. The potential for early resolution and cost saving, which is what this has always been about and should remain as its goal.
Okay.
I was out of time a long time ago. My apologies.
No, that's fine. That's good testimony. Well, thank you. Members, any questions? Okay. Well, thank you. The chair calls